Okay, good morning, everyone. I'm going to call to order the Martin County Code Enforcement Magistrate hearing for April 16th, 2025 at 9 a.m. If you'll please rise, join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, please be seated. The first case I'm going to call this morning is the Meadow Run Property Owners Association, Inc. case. It's case number GMD 2025-010355. It's a violation case, and Officer Mitchell and Mr. Schilling, you're both going to testify?
Yes, sir.
All right, and good morning.
Morning, Mr. Magistrate. This is Scott Lee for Meadow Run Property Owners Association, and I have Jeff Cable, who is a board member of Meadow Run Property Owners Association.
All right. Good morning. And I'm sorry, is it Cable or Gable?
Cable, C-A-B-E-L.
Okay. Scott, I'm sorry, tell me again.
Scott Lee.
Lee.
Yes.
That's easy.
Easy enough.
All right, gotcha. All right, so it's a violation case. We're going to hear from the county first. Assuming they make a prima facie case, then we'll continue on. Usually they follow the script, and it is a prima facie case. So after that, you're welcome to call witnesses. You're welcome to ask them questions, just like you might in county court. So, okay. All right. All right. If you'll raise your right hands, and Mr. Cable, if you will as well. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, very good. Mr. Mitchell,
Yes, sir.
whenever you're ready.
Okay, my name is Jerry Mitchell. I have been sworn in. I am a senior site compliance officer for Martin County. The respondents, Meadow Run Property Owners Association, we do have members here on behalf of them. On behalf of the county, I have Paul Schilling and also Elise Elder, Deputy County Attorney.
Morning, Ms. Elder.
Good morning.
This case concerns the property located at 4701 Southwest Stony Brook Way, Palm City in Martin County. This case was not generated from an anonymous complaint. According to the official records of the property appraisers of Martin County, the property owner is Meadow Run Property Owners Association Incorporated, formerly known as Fox Grove. Copy of appraisers, record of ownership is County Exhibit 1. On January 17th, 2025, I received a complaint that the Meadow Run community is gaining access into the community from Southwest Layton Farms Avenue. According to the approved master site plan, access from Southwest Layton Farms Avenue is designated for emergency use only. A little background, in 2004, the property received an approved development order and master site plan for Meadow Run, formerly known as Fox Grove. According to the general note number 19, the approved master site plan states that all access should be done into the community from Southwest 48th Avenue. However, Layton Farms Avenue is to be used for emergency access only. So in County Exhibit 2 here is the master site plan, and I have kind of marked up here, I'll enlarge it. First thing I want to point out is under General Note 19, it does specifically say that all lots will be accessed internally via the access of Southwest 48th Avenue. Layton Farms Road is to be used for emergency access only. And that red box I put on there for simplicity's reasons. Also, here's the 48th Avenue section of, and it also named as Citrus Boulevard. And here's the main entrance into the Meadow Run community. The approved location of the 20-foot access that is used for emergency purposes only is right here between lots 49 and 50. And this is where the emergency access only is to occur.
Okay.
What we have going on is that's not being used at this present moment. Where the access is occurring is down here on the south end of the Layton Farms Road, which is actually a dead-end street, and this is where the prohibited access is occurring.
What is to the east of that turnaround where your arrow is.
Yes.
What is it?
The street itself is Layton Farms Road. To the east of that is another property. And let me see if
So there is a road there.
So if I go to Exhibit 3, maybe this will help explain that a little bit. Again, it's just as a 2024 aerial view of the subject property, and what I'm showing here is the 48th Avenue main entrance. I'm showing the approved location on the right-hand side at the top there, which is the north area between lots 50 and 49 is where the approved access is. And then as we move down south here, this is Layton Farms Road. It's a dead-end road to the very south end, and the prohibited access is occurring right here by this cul-de-sac.
Okay,
Okay.
all right.
On January 24th, 2025, I inspected the property. At that time, I observed non-emergency access occur into the Meadow Run community from southwest Layton Farms Avenue. At this time, I photographed the property, and the photograph actually shows what I saw then. It's going to be marked as County Exhibit 4. And all the exhibits that I will be presenting today will be from this southern portion of Layton Farms Road where the prohibited access should not be occurring. Let's see if I can. So the first picture on the left here is what I'm showing is I wanted to document the fact that the gate is open, or is that there's unrestricted access available here, and that also there are gates on here.
And where are you taking the picture?
All right, where I am in this picture, I'm east of them on Layton Farms Road, taking a picture to the west.
Okay,
And while I was there, I observed the access occurring with this truck coming in with that trailer on it, and into the off of Southwest Layton Farms Avenue into the community. Let me get this back. What happened to this? Give me a second here. Oh, there we go. Okay. So that was County Exhibit 4. Okay, but during that inspection, I met with Meadow Run Board member Jeff Cable, who acknowledged knowing that the access off of Southwest Layton Farms Avenue is designated for emergency use only. Furthermore, he informed me that the board intends on revising the site plan to allow access to occur here. I just simply explained to him that please keep the gate closed and locked to ensure that the access is restricted to maintain compliance until a revised site plan can be approved. On January 27th, 2025, I conducted a follow-up inspection and observed that the gates had been completely removed, now leaving the access completely open and unrestricted. At that time, I photographed the property, and the photograph actually shows what I saw then, and that's going to be marked as County Exhibit 5. So now the gate is completely off. My understanding was that when they went to close it, it kind of collapsed to the ground, and they just didn't have time to put it back up. On January 28th, and also on January 30th, I conducted subsequent inspections and observed no change. The opening remained unrestricted and prohibited access continued from Southwest Layton Farms Avenue into the Meadow Run community, and they're going to be marked as County Exhibit 6. County Exhibit 6 was taken on January 28th. I am again still looking to the west, so I'm on Layton Farms looking west. You have 4 vehicles I captured going into the community there. And I followed up on January 30th. Again, I captured another 4 vehicles coming in and out.
Okay.
Based upon the investigation, I issued a notice of violation to Meadow Run Property Owners Association on January 30th, 25. And that notice of violation is marked as County Exhibit 8. So in this notice of violation, we did cite Section Code 10.14.g, failure to comply with the conditions of an approved development order. We just basically asked them to cease all access coming in from off of Southwest Layton Farms Avenue.
Okay.
Okay. In the notice of violation, I've kind of already said this, they were supposed to cease use in this access. On February 14th, 2025, I conducted a follow-up inspection. At that time, I observed that gates had been installed near the cul-de-sac off of Southwest Briar Brook Way and not reinstalled in its original location along Southwest Layton Farms Avenue. At that time, I photographed the property, and the photograph actually shows what I saw then. It's marked as County Exhibit 9. So again, this is where the gate was installed near the cul-de-sac off of Southwest Briar Brook Way. Kind of served to be kind of ineffective at the time because people were able to drive around it, which I'm going to be able to show here in a minute. On February 19, 2025, I conducted another follow-up inspection. At that time, I observed continued access occurring from Southwest Layton Farms Avenue into the Meadow Run community. At that time, I photographed the property. The photographs actually show what I saw then. They're going to be marked as County Exhibit 10 and 11. So 10, we have this silver truck coming. Again, I'm east of it, taking my picture to the west off of Layton Farms. Silver truck coming through, and the driver just drives right around the gate. And Exhibit 11 is the same, where you have this maintenance truck coming through, and again, they just drive right around the gate.
Okay.
On February 26, 2025, I conducted a follow-up inspection and observed that the gates were open. At that time, I photographed the property. The photograph actually shows what I saw then is going to be marked as County Exhibit 12. So where they put the gates, at this time when I was there on February 26th, it was open. At that time, I contacted Jeff Cable, informing him that the gates were open. In addition to that, I informed him that for the installation of the gate required a building permit, and therefore I would be issuing an amended notice of violation and notice of hearing. And in the meantime, I advised him to remove the gate and reinstall it to its previous location off Southwest Layton Farms Avenue, for this would be considered a repair versus needing a permit. Based on the investigation, I did issue the amended notice of violation and notice of hearing on February 27th. In that, I cited Section Code 10.14G, failure to comply with the conditions of an approved development order, and I also cited the Florida Building Code, Section 105.1, Florida Building Code. In the notice of violation, respondent was informed to immediately stop all non-emergency access at Layton Farms Avenue and to either obtain a building permit or remove the gates. As of March 6, 2025, the return receipt was not received. Therefore, I hand-delivered the amended notice of hearing to Mr. Jeff Cable. I executed affidavit of delivery, and that's going to be marked as County Exhibit 14. On March 12, 2025, I re-inspected the property and observed that the gate was removed from the cul-de-sac and reinstalled at Southwest Layton Farms Avenue. At this time, I photographed the property. The photographs actually show what I saw then is marked as County Exhibit 15. And at this time, when I did take this photo, the gate was locked and secured. It was securely attached to each post on each end. Based on that, I did close out the case. On April 1st, about 19 to 20 days later, I responded to the property after receiving a voice message from the complainant that access is occurring again onto the property off of Southwest Layton Farms Avenue. Upon my arrival, the sheriff's office was on site, for they were called as well. I observed that the gates were open, and I observed a pickup truck accessing the property from Southwest Layton Farms Avenue. Once that truck passed, the deputy and I closed and secured the gate. Based on what I observed, the enforcement case was reopened. Therefore, on April 2nd, 2025, I issued an amended notice of violation and notice of hearing to the respondent with the hearing date scheduled for today, April 16, 2025. I also, on the same day, I hand-delivered the amended notice of violation and notice of hearing to the Meadow Run board member, Anne Marie Height. The amended notice of violation and notice of hearing is marked as County Exhibit 16. So again, and this notice it was issued on April 2nd, and we went back to just the section code, section code 10.14G, failure to comply with the conditions of an approved development order, and basically asking to immediately cease all this activity. Like I said, I did a hand delivery that same day as well, so I did an affidavit of hand delivery, and that's going to be marked as County Exhibit 17. On April 15, 2025, prior to today's hearing, I re-inspected the property and saw that the gate at Layton Farms Avenue was closed, however, it was unsecured. During the inspection, I observed a delivery driver exit the property. At that time, I photographed the property. The photograph actually shows what I saw then is marked as County Exhibit 18. So here, when I first got there, the gates are closed, and then as I sat there for a few minutes, the driver came up, opened the gate and exited and came out. He did come over to me and he said it's a combination lock to the gate. He said he had the combination lock and he was able to open the gate and go into it, and that's how he gained access. I request that all the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent Meadow Run Property Owners Association be ordered to comply with the cited provisions of the Martin County Code by compliance date outlined in the order, and if not in compliance by then, would be required to pay a fine in an amount of $500 for every day the violation continues thereafter. The county has incurred costs in an amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing. This concludes my testimony at this time.
Okay, and the date you've requested for compliance is?
The date is for tomorrow. I mean, they just need to secure that gate, so we're asking that they secure that gate by tomorrow.
Your Honor, I have a couple questions. Elise Elder, Deputy County Attorney, for Mr. Schilling, if possible, before we rest. Mr. Schilling, can you please state your name?
Paul Schilling,
And what is your title with Martin County?
Growth Management Director.
And as Growth Management Director, is part of your duties to review site plans and ensure they're in compliance with the land development regulations?
Yes, ultimately, yes.
Is that like a daily task on your part?
Yes.
So when you're reviewing a site plan, is there a distinction between an emergency access and a construction access?
There is, in fact, would you like me to elaborate?
Please.
So the emergency access, Your Honor, and good morning, is intended for those emergency services, meaning fire rescue, law enforcement, and those activities. And those are generally part of most developments. And they are typically secured with what's known as a Knox box or some type of other apparatus that would allow the emergency services to access. Construction access points are part of the development review process. Those are reviewed and ultimately approved typically as part of the site construction or site prep permit with the original approval. There is no such, that we were able to determine, no such construction access point. In fact, when this development was approved in 2004, there was, as Mr. Mitchell indicated, Note 19 prohibited access to Layton Farms, with the exception being the approved location for the emergency access, which is located between Lot 50 and 49, which is there today.
So even during construction, there was no construction entrance requested and none granted by the county?
That's my understanding, yes, sir.
So the construction access on that road, the emergency access on that road is only for emergency vehicles. It's not appropriate for construction vehicles?
That's correct. There's a clear distinction always on what the parameters are with that. And the construction access, as you can imagine on some of these projects, is sensitive. There may be resources in the area. There may be things that need to be cleared to provide that access. So in this case, this subdivision, my understanding is the approval process, and this was some time ago, would have directed all that traffic, with the exception of the emergency access, off Citrus Boulevard.
And are accesses approved in the final site plan?
They are, yes.
Why is it important to have a construction access or any access approved prior to someone actually using the access?
access points there are code requirements with respect to the surrounding neighborhoods and those roadways or right-of-ways and how those are utilized. So there are strict parameters with respect to access to all development.
Because of traffic impacts?
Correct.
No further questions.
Okay. Mr. Lee?
Yes, thank you. So we're not necessarily contesting any of the facts or the testimony. It needs to be put into proper context. The reason why these construction vehicles are utilizing the particular point that is being complained about is because the main access point into the community is inadequate to allow for construction vehicles to enter upon the community. We have 90 or so lots in this community. There's only 30 or so homes that are constructed. There's ongoing construction at various lots. Homes are being constructed. So you have large construction vehicles, trailers, trying to make their way into the community. And for those particular vehicles to try and access the community through the main gate, it's virtually impossible for whatever reason. And it's causing damage and has caused damage. And I could have Mr. Cable testify as to this. When those large construction vehicles are entering upon that main gate, which is on Southwest 48th Avenue, it's caused damage to the building structure right there, as well as other damage to landscaping, et cetera. As a result, what the association has done is filed an application with the county for site plan amendment, and in fact, that's pending right now. There's a major site plan amendment that is pending, and there's a completeness correspondence from the county saying all documents are in. We expect that there'll be a hearing before the county commissioners probably in 60, 90 days or so, with anticipating that a separate entrance, namely the point on Layton Farms Road, is going to be approved with a swing gate and utilized for all access purposes, particularly for these construction vehicles, which cannot make its way into the community otherwise.
Okay, and you're talking about the access point at the south end, I guess, of Layton Farms Avenue? Not the emergency location?
That's correct. That's correct.
Okay.
So where the temporary gate currently exists, there's an application to install a swing gate system, 2 swing gates, utilizing the existing, it's not a cul-de-sac, but turnaround that you may be able to see on this site plan, on the plot plan. And we anticipate this is going to be approved. And frankly, it has to be approved in our estimation because there's no other way for construction vehicles to make its way into the community. Whether or not there was an error many, many years ago by whomever to say that the only way to enter upon this community for these construction vehicles is through Southwest 48th Avenue is neither here nor there at this point. But we have to allow these vehicles to enter the community so people can build their homes. We understand, though, that a site plan application is necessary. We're going through that process. We submitted all the documents, paid upwards of $9,000 in fees, and we anticipate being before the county commissioners in a few months. So we respectfully request that the compliance date be put off until after the county commissioners make a decision as it relates to that application.
If I may respond, Your Honor?
Go ahead.
And
Okay.
if I could have
Oh.
Mr. Cable
Yeah, I just
add
want
some
to,
flavor to this as well.
Your Honor, I don't want a little bit of a correction because what we submitted to the county, to the growth management, was not to actually construct anything. It was just to change our PUD and remove that note 19 that was, giving us restrictive access off of Layton Farms Road into our community. So that's what is going on right now with the growth department.
Is to amend note 19?
Yeah,
How
again,
how
note
would you propose to amend it?
I think Mr. Schilling can probably testify as to what the application provides.
Your Honor, may I? So we do, in fact, have an application that was submitted by the HOA. is for a revised major final site plan. And the proposal is currently under review as of about yesterday or the day before. So it was transmitted to the reviewers. There is a whole team that make up the review process in the county. That is a 45-day review, I believe, if I'm not mistaken. So based on my experience, it's probably realistic to think that this may, at some point, approach approval status to the Board of County Commissioners, meaning that they are the decision makers as part of this application or this application. So the timeframes involved are going to be, the county has our timeframes, but also applicant responses. So ultimately, it is going to be the Board of County Commissioners that presumably either approve or deny access on Layton Farms. So, so it is ongoing.
Okay.
Do you have an estimated time frame on how long that would take?
I
It'd
need
be up to a
ask.
year.
Generally, applications with revised major final site plans can take upwards of 8 months to a year to complete, depending on the complexity and the scheduling of board items.
And just one more point, Your Honor, and I think Mr. Mitchell can testify to this. Did you witness any construction trucks going through the front entrance?
Yeah, on April 2nd, when I was there, a tractor trailer with a load of sod did come through the front entrance of the.
And is it a tight fit?
I didn't actually observe him maneuvering through it. As I was driving out the gate, he was already in.
But he could get through the front.
He got in, yes.
So the county's position is that they can utilize the front. It might be a tight fit, but they still can utilize it. That doesn't, and the fact that they don't have the ability to use it is not reason to violate the land development regulations by creating your own access in violation of your site plan. But our position is that they can utilize the front. It's a tight fit. They have to be careful, but it's still, they can still utilize it, Your Honor.
Your Honor, if I may. So those that may have not been out to our community and to actually see the actual, I wish I would have brought pictures. The front entrance, the design of it with the guardhouse there is such that the curves are so tight, and we're not talking about your standard, box trucks and, well, even some of those because they're just so large. But there's others that are, oh, I'm sorry. There are others that are, just these enormous pump trucks. A sod truck, they have various sizes, so I'm not sure which one Mr. Mitchell observed that day. But the one that you saw in the picture, that with that very long flatbed, that carries trusses. Those trusses, it's impossible for them to make their way through that front entrance because the trusses overhang, those beds. There has been numerous times where the structures in and around the front have been damaged, so much so that in our maintenance crews, we've almost had, on several instances, them, actually bits of the building come crashing down around them. And we've had to obviously repair, and we'll do what we have to do to maintain that. But we feel that that's just such a big hazard. And so if I may go back to some of, and I don't contest what Mr. Mitchell's presented to you, neither. But we've tried to work within the constraints of what we have in our community as a building and a developing, community. We're 91 lots, 36 homes currently built. We have I think 3 or 4 under construction right now. We have another several that are in review currently. And that area in the back off of Layton Farms Road, when in 2021, I did present to growth management, to actually start the process of having our PUD, minor, site plan change, to get that Note 19 removed. However, it was stopped because of other construction that was going to be taking place on Layton Farms Road at the time. So fast forward now to this point in time, that entrance area where you see the gate removed, what happened was the gate just became so destroyed we couldn't even close it physically. It was just like literally just, so damaged. And So we hired a contractor, and that's why there was a little lag between, you know, the time that the gates were off and then it was relocated. We thought it was best to move it to that interior side because it provided that roundabout and ingress egress for all the vehicles and maintenance and whatnot that we had kind of already steered to go around to that back entrance, give them a little bit of time to readjust. Since then, Your Honor, I would say 99% of most of the maintenance and regular construction vehicles, we do have them come through the front. It's these really enormous vehicles that we just simply can't have, they just can't maneuver. It's very, very frustrating, you know, for us, for that reason, you know, I don't care about the damage to the building, that's one thing, but I'm worried about, you know, somebody being injured, and that's a big liability on, you know, for our community to, you know, to take on. Not when we have something that's easy for us to just be able to access if we, you know.
Let me ask you this. I note that the community name Foxgrove was, and it looked like this was, site plan was back in '04, '05, somewhere in there. Has that ever been amended up through, you know, now, the site plan?
Paul Schilling, for the record. No, not that I know of, Your Honor.
Even though it's changed names, the community has changed names.
Correct. Just for a little background, this community and the applicant can talk about this, but this has remained, the infrastructure was installed sometime after 2004, of course, and it remained pretty sparsely inhabited with respect to those lots for many years. And up until probably several years ago, there was renewed interest in the development and more construction activity occurring. So it's probably safe to say that for quite some time after the approval, there wasn't much activity other than maybe a couple lots.
All right, and let me ask you to zoom into I'm looking at, I guess. let's
Exhibit
see,
3 here?
What was marked as Exhibit 2.
Oh, you want to go back?
Incidentally, just to tidy things up, does anybody have any objection to the county's Exhibits 1 through 18?
No.
All right, so without objection, I'm going to accept those into evidence. Let's zoom into that entrance feature.
Over here.
Okay. And let me just ask, Mr. Cable, is that pretty much the way the feature actually looks, that entry feature?
Well, with the exception that there's no structures, you know, on there, because that's the original
All
one.
right,
the
so maybe
developer-
let's look at the photo, at the aerial.
Photos of the front end?
It's Exhibit 3. And just zoom in. I don't know whether that's going to show it either.
Give me a minute here, and I think I can find a picture of it. I'm going to do this without messing this up. Can't I get this? That didn't work. It's yeah,
Software issue.
that didn't work.
We can go to Google maybe.
Yeah.
If you got that there.
Bear with me, I'm going to pull up the property appraiser's bird's eye, or,
Yeah, it is.
so here is the entrance. Just go here. That didn't work. Why did that work?
Click down, just click on one of the lots.
Should be able to get bird's eye here, I believe. Or we want Google Earth Street View. That's not working. Figures. Let me see if I can,
Okay.
let me try the bird's eye view. One more attempt here, sir.
I guess I'm just trying to understand
So with the,
how it got created that it would be difficult to access.
that's not,
That's it.
All right, so that's coming off of Citrus Boulevard?
Yeah, that's-
Is that at the bottom?
Yes, but the lower street is Southwest Citrus Boulevard, Southwest 48th Avenue. This is the main entrance into the Meadow Run community.
Okay. And it looks like the roadway goes under some sort of a portico feature?
correct. And then there's columns, you know, on the, in between that separate the, and the little island that separates the two little paved, you know, parts going in. And if you see that curve there, it's not for like a normal standard truck or, you know, pickup trucks or anything of that nature. It's those really large trucks. They just simply can't make that tight turn. And, I mean, again, their only choice is to run into something, run over something, you know, causing damage and possibly injury to, you know, somebody. And you can't, if we were able to steer them in going straight in more, that'd be great. Unfortunately, it's not wide enough, and that's where the structural damage, you know, keeps occurring because the height of the, you know, is just not tall enough to accommodate most of those, you know, a lot of those trucks. So they're doing damage to the building, both on the side and up on the top. That's some of that where we've had literally issues with some of the structure coming down and almost, you know, hitting some of our maintenance people. So that's where we're at, and coming out is no better. I mean, that's even almost worse because it's a much narrower and tighter, you know, radius. I wish we didn't have that design. I wish it was straight in. It would be, we wouldn't be sitting here today, but unfortunately, this
Okay.
is what we're up against.
Let me ask the county if it were that the community, until this issue is decided by the county commission, were to prohibit use of this makeshift ad hoc entrance except for tractor trailers, 53-foot trailers. Would that be acceptable to growth management?
So I don't think the growth management has the authority to make that determination. The site plan specifically says what the access is limited to, and so the land development regulations, so staff doesn't have authority to allow someone to violate those things.
Yeah, and I understand that, but
So
perhaps I do.
that is up to you, Your Honor.
Honor, may I? Just from a practical sense of, I would suggest that we've expended a significant amount of resources and time just getting to this point today. And I would also suggest that a similar matter has come up years ago, and I believe it was in Martin Downs, and the idea of enforcing construction traffic in a private development would essentially require a posting of an individual at that site with respect to compliance,
Yeah.
and would be very difficult.
Well, so we're not believing in the honor system, huh?
Not
I'm a big
after the
believer in
history that we've been dealing with.
I'm not saying it's impossible, but we certainly don't have the resources to dedicate an individual to.
I understand that, and I wouldn't anticipate that you should have to do that.
Sure,
I-
Mr. Magistrate, neighboring property owners may end up monitoring this and providing evidence to code enforcement if there's not compliance, so we don't necessarily need to have.
It sounds like that may be how we got here in the first place,
Yes.
but
Along with just simply putting off the compliance date, which is within Your Honor's authority, which would
Yeah.
buy us the time necessary to go through the county commissioner process.
And I appreciate the self-help issue, but if you were of a different age, Mr. Cable, I would say you've been naughty. You basically have not abided by the site plan. And as a result, that's why we do find ourselves here. Is there an opportunity for the county staff to expedite this and get it in front of the county commission sooner than 9 months or 8 months or?
That's a thing that we can't guarantee. It depends on submittals, it depends on turnaround. We also have 90 other applications, so normally that's not something that we can
Out of
promise.
control.
Yeah, it's definitely out of staff's control, and I'm speaking for Mr. Schilling, but I think that's,
No, I think I understand that part. So a lot of this does depend on your willingness to participate. So if there are comments from the county staff and requests for additional information or drawings or whatever it is, I mean, it would be up to you then to produce that as quickly as you can. I am willing to order compliance by tomorrow, with perhaps the exception that if there are vehicles that it would be inherently dangerous to go through that gate. And I'm thinking, based on what I've heard, all of the testimony, that the only exception would be large tractor trailers. And I think until this question is resolved, that's not unreasonable to do. But that's the only exception. And if the county catches you, then I would take that permission away immediately and make it so that that everybody has to go through the front gate. And it would be up to the contractors to figure out how to do that.
May I also request that, again, I stated there's the big cement pump trucks, that the height of them, they just can't get through. I mean, the height, they're the ones doing most of the damage to the actual building. Those are the ones that's a very long, but it's not necessarily 53 feet. I don't know what the length is, but the height is very restrictive for us to try to get them in through that front as well. And those are really the vehicles, Your Honor, that we've just tried to get just going to the back. Everything else, again, we've got
Do you have
steering.
staff? Do you have somebody that can actually open and close the gate? You're it.
Yeah, I mean, and I've done it in the past, and, it's very frustrating, because unfortunately, and I have secured the hinges, just to let you know, because that's also been a problem, where we do have people remove the gates entirely off the hinges. So I personally have made a lot of effort trying to, secure that back. And it's unfortunate that we've gotten to this point, but it is what it is. And yes, we will comply with whatever we have to comply with. That's not an issue.
All right. And I think that's exactly, based on all of the testimony, all the evidence that I've looked at, and argument of counsel, that in fairness and in safety to the community, it probably makes sense, one, to require compliance as of tomorrow, no question about that, with the exception of these large and tall trucks, perhaps.
Your Honor?
Yes.
We're going to suggest, if we do this, can they use the north location that is on the site plan as?
I have no idea. We never really looked at that, and it doesn't look like, is there actually a road there?
Your Honor, that is so degraded and it's also traverses a main artery of our drainage ditch that's South Florida Water Management permitted to us. And because of the degradation, it would not, first off, a truck can't even make that turn. It's just so tight, it's an impossibility. Any large, long, we've tried, believe me, we've tried. I've tried everything. That's just not going to be possible. And those really heavy trucks, like the pump truck that I'm talking about, Mr. Mitchell, that would in fact collapse that entire area going over that drainage ditch.
Is there a culvert there?
Okay, well,
With the
let's-
culvert
let's
and all
look at
that, correct.
Is
So
that
this
the
is-
access?
This is the access, yes, that's 50 and lot 40.
And is it paved?
It was
some kind
paved
of-
back in 2004, and it's never really been maintained because it was really not for anything. But it's that apron area that is actually, it's owned by property owners because we do own, our property line does actually go, if you look at where the taller, looks like vegetation, on the other side of the taller trees, going out towards Layton Farms Road, the people's property lines do actually extend just beyond the actual drainage ditch. So the drainage ditches are actually, in part, well, we maintain them because we're required to.
They're in your community.
Correct. So, but if you look at that area, and I welcome Mr. Mitchell and anybody else from the county to come and inspect that, but that area is just so iffy. To even drive my pickup truck over it is a little bit,
Precarious.
It's an approved emergency access on the site plan. It has to be maintained, so technically they're out of compliance with that as well. So I don't know that that's a good reason.
Is that also gated?
there is a gate there, yes.
And does it have a Knox box so that,
There is a Knox lock that I don't know that was on because we had to actually replace that gate as well just recently. There is a Knox lock that I think it's on the old gate, but yes.
Your Honor, may I just,
yes, sir?
the access point, I was not with the county in 2004, but the requirements are for emergency access that it meet the requirements for obviously a fire truck and any other emergency equipment. So it would have been required to be stabilized in accordance with those regulations and also provide the width to get fire trucks in and out of the community, as well as in the front of the community. I want to stray a little bit from this and maybe offer a little consideration to the applicant. The front, I only was aware of the issue potentially of tractor trailers coming into the community recently, but there is an opportunity perhaps to modify that gatehouse to remove the porte cochere over the one lane. And so that may provide on access to semi-trucks without
In
any.
an ongoing basis,
Correct,
yeah. Not something that's going to happen tomorrow.
correct. But that would be an application, assuming it involved no pavement or other improvements. Clearly, with respect to the gatehouse, that could be done by way of a building permit, perhaps. And I'm just using that as an example. The other part of that would have been there is no architectural or requirement for that gatehouse on the site plan. There is simply an entry feature. So it is not, the design of that gatehouse is clearly certainly up to the community.
And the building permit would be a much quicker process than the approval of the board to get the access. So that is an alternate route if they want to remove that.
Mr. Magistrate, that's an alternative, but
Yes.
we've spent $20,000+ in an application with the county to build the swing gate entrance on the point of contact that we're discussing today. But if the county commissioners disapprove it, then sure, we could go in that direction. But we're pretty far down the road as it relates to the site.
Well, it's not up to me to tell your client how to comply. I'm here basically just to tell the community that they must comply. And what I'm considering and what I will do is amend this draft order to allow for oversized, large trucks until the decision is made by the county commission. And then once that decision is made, it either will be, no, you don't get access back there, and that'll be it, and you'll have to deal with it some other way, which may be modify the front entry, but that's, as you say, Mr. Lee, down the road. So,
Yes.
all right.
Do you want us to provide a new prepared order? Were you handwriting it?
That
in?
would be good, because
Okay.
then you all can bounce that off each other, and if you have any comments, Mr. Lee, you can get
Chance
those.
to review it, I'd appreciate it.
Sure. Are we defining the size of the large tractor trailers or the
Well,
height, so we have
We know
parameters?
that a tractor trailer normally is what, a 53-foot trailer? If it's,
Height issue with the cement trucks.
and the height of these. And a pump cement truck is different than just a regular concrete mixer.
That's correct. Yeah, because it comes with some apparatus that deploys the actually arms and whatever.
Okay.
I don't know the specific heights on that, neither, so.
We'll let
can
Ms.
figure it out.
Elder figure out. how to
We'll figure it
define
out.
But I think we all understand
Yeah.
what we're talking about, so, okay. All right, anything else on this case?
No, Your Honor, thank you.
All right, good, thank you very much. Oh, let me once again tidy things up. I am going to order compliance, and failing which, there will be a fine in the amount of $500 per day. So comply, okay? And I totally agree that this has gone on long enough. There's been a little bit of cat and mouse, and that's not a game that I'm willing to entertain. And there are costs in the amount of $575 that I'm going to award to the county to be paid actually upon entry of the order. So
Is that on a go-forward basis, Mr. Magistrate, or?
the go-forward basis is compliance starting tomorrow for everything but tractor trailers and cement and concrete pump trucks. If they violate the order, then it will be from here on out.
It's prospective,
Yes. Yes. Okay. All right. Thank you.
Thank you.
Okay. All right.
If you couldn't get around shit like that, nothing would have moved. We got tractor trailers.
Okay, now I'm going to try and take cases for folks who are here first, so.
We took a fender off a park car every now and again, I will admit.
Sure. Yeah, but you got it done.
Yeah.
I usually take it by who comes in first.
There's room. That's
why I thought
like
it was
a lawn there, and this, maybe there's a tree, take the tree down, drive over the grass. Cut the tree down. Cut the tree down, put a new tree, I like
To
that.
your house later and have you sign it?
That's fine. Elise, I guess, is going to,
We're gonna find you.
Yep.
And then once I get it.
and just bring it. Yeah, that'd be great. Thank you, Jerry. All right, let's see.
So you're gonna give him a continue? and read-
Second case I'm going to take is the Worley Estate case. It's on case ENF 2025-01-0048. It's the estate of Donald H. Worley. And Ms. Esbiant, you're going to testify. Let me just grab the order. Okay, and we have folks here.
Yes, we do.
Okay, all right. If you'll raise your right hand, do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, whenever you're ready.
My name is Maria Espea, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Worley Donald H. Estate, a representative, is present. This case concerns the property at 3211 Southeast Clayton Street in Stuart, Florida, and Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Worley Donald H. Estate. A copy of the property appraiser's record of ownership is County's Exhibit 1. On December 30th, 2024, I inspected the property. At that time, I observed high grass, trash, and inops. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibits 2, 3, and 4. 2 shows high grass on the side of this property, some in the front. Exhibit 3 shows inops, although you can't really see it too well because of the shadow.
Inops are inoperable vehicles.
Correct, inoperable vehicles.
Okay.
Sorry.
Helping
And-
the folks at home.
And number 4 shows another inoperable vehicle missing a tire and trash against the home. Based upon the investigation, I issued a notice of violation to the owner on January 9th, 2025, marked as County's Exhibit Number 5. In the notice, I cited the following Martin County Code violation: Section 67.201A, nuisance declared weeds, undergrowth, general ordinances, Martin County Code; Section 67.201B, nuisance declared trash, etc., general ordinances, Martin County Code; Section 91.34A, generally inoperable vehicles, general ordinances, Martin County Code. In the notice of violation, the respondent was given until January 23rd, 2025 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail and regular mail on March 19, 2025, and that is marked as County's Exhibit 6. The return receipt was not returned. Therefore, on April 1st, 2025, I posted the property and the Martin County Admin Building. The affidavit of posting is marked as County's Exhibit 7. Therefore, I went back to the property again on April 15, 2025, and saw the cited violations had not been corrected. At that time, I photographed the property. The photographs accurately showed what I saw then and are marked as County's Exhibits 8 and 9. 8 shows all the items considered trash against the home. And 9 is just another view of the trash. The inops and the grass violation was corrected, however.
Okay.
I do request that all of the county's exhibits be received into evidence, but we are also requesting a continuance based on photos that the owner has brought this morning.
All right. Let's call the owner up and see what we've got. All right. Sir, if you raise your right hand, do you swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes, sir.
All right. And what's your full name?
Donald Herbert Worley Jr.
Okay, and you represent the estate in this case?
Yes, sir. Yep.
Okay.
I'm taking over the estate. My father had passed. It was my mom and dad's. Mom passed. Dad just passed within a year.
Okay.
So now it's playing catch up, and I got a lot going on. A lot.
Okay, and Ms. Esbiat said you had some photos you wanted to...
Yes, sir. Of being more compliant, got more stuff. We've been cleaning out the house, so like a lot of the stuff it's there and then it's not there. Certain stuff is, my grill I have right there because I cook in my driveway. My kitchen is right off the driveway, so instead of having to walk all the way, through the house or around it, we cook right there. And it's just been a lot of cleanup, a lot of stuff coming out of the house. Pile it up, take it down the road, pile it up. So a lot of it's intermittent because I still have work. Working for myself, I've been out of town, been here, there, and everywhere. And I have my roommate helping me, but some of the stuff he doesn't know what I want to keep or get rid of, so it gets piled up.
Okay, are you presently
I'm
living
present-
in the house?
I am staying there, yes, sir.
Okay.
Yeah. So
All right.
I'm just constantly rolling, just getting stuff out.
Why don't you show us what you've got?
Sure,
If you put the photo on that white...
Okay. It'll
Yeah, there.
show through.
Yeah, we'll be able to see it.
Trying to make it big here for us. Does it matter which way it's faced?
It probably does.
Tell me which way I got.
That looks good.
That's this morning, right now, fresh, just while I was here.
Okay.
As you see, I got the hose reel right there, and there's a container right behind it, because that's another wall, but it's recessed down behind it, like a planter box. That's got hose nibs and fittings, and it's just all yard equipment that we use. And then there's another view of the front. I
All
just
right.
have my little
So-
sofa seats, porch seats up there, and nothing else.
All right, so the grass continues to be cut?
Absolutely.
No
I
issue
just,
there?
yesterday I just spent $411.89 on parts for my mower because I destroyed my mower trying to stay compliant with my lot that is next to, they're two separate. The house still has a mortgage, so I don't have the deed for it, but my lot is paid for. Well, when they redid the neighborhood, they asked to use the lot. They've signed off that the lot was complete. I still have asphalt, concrete from the sidewalks. They lowered my land, and it just, so I didn't know that had been signed off on. When I got the notice, I was like, I spoke with her. I said, this, and, hey, these guys never finished what they started. I still had signs laying in the grass from where they did all that. So I tried to comply. I went and started my mower up, ran through there, and that's when I found out all this extra mitigated material was left behind. And I'm not putting that on code enforcement because I didn't know that had been completed. My opinion, it's not completed.
All right.
But that's outside of this.
Yeah, that's not why we're
But
here today.
I tore my mower up, so now I've been having in money. So I've been taking care of the grass with just a weed eater. That's a large lot to have to weed eat. I'm talking 4 hours running a weed eater to take care of the grass and the land. It's a lot of work. So it gets done in stages, but now that I've got it to where it's manageable again, I've cleaned up quite a bit of the construction material, so my overall maintenance is being taken care of.
And I
Yard
can see
maintenance.
that in the photos. And then actually, I think.
You
that's the odd-
it's a big
presented that as well.
improvement. Yes.
Yeah, so what is the county asking?
Only because these pictures were taken this morning and
Yes.
I didn't personally see this.
Yes.
I would like a continuance so that I can go to the property even today and just.
I
take a
would like to
picture.
actually be home or be present with you, because I know it's a weird thing about being on people's property without, I give you full permission to come on my property, because I would like to be able to walk around and say, all right, so this area specifically, how can if it's something that needs to be adjusted, I can address
So if I
specific
continue the
areas.
case for the next.
Yes, for the next hearing.
All right. I think that's the simplest thing. That'll be.
Yeah,
the
I want to be
cost
compliant with
effective.
everybody. I want us all to be happy.
All right. So I'm not going to accept any of the evidence today. If we have to come back, it'll be a complete do-over.
Okay.
Okay, so nothing is in evidence. I will continue it to, let's see, what is the date of the next hearing? It is May 15th, no, that's last year. That's last year. I'm sorry, Ms. Bradley?
May 21st.
May 21st.
Yes, sir.
She's just ignoring it and saying, I don't want to hear it.
All right. All right, so basically between now and May 21st, you all hopefully get this all
We'll
worked
definitely get
out.
together and, we'll make sure that
If-
all of us are happy.
If not, I'll see you back here on May 21st.
I hope not.
I hope not either.
All right. I thank you.
Okay. All right. Third case is Ida Rissischer. Am I saying that right? It's case number ENF 2025-010356, Ida L. Rissischer, inter vivos declaration of trust. You're here. Okay, great. All right, we're going to hear from Ms. Carrasco. If you'll raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and sir, this is violation case, kind of like the others that we've heard. We're going to hear from the county first, and then I'll call you up. Whenever you are ready. Okay.
My name is Deborah Carrasco, and I have been sworn in. I am a code compliance investigator for Martin County. The respondent, Ida L. Rusasher Intervivos Declaration of Trust, is present. This case concerns the property at 155 Southwest Canner Highway, Stuart, Florida, in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Ida L. Rusasher Intervivos Declaration of Trust. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On January 16th, 2025, I inspected the property. At that time, I left a door tag, which is marked as County's Exhibit 2. The following day, I went back to the property. At that time, I photographed the property. The photographs accurately show what I saw then and is marked as County's Exhibits 3 through 7. So there are 3 separate buildings. This one here,
And the one on the left is,
the one on the left, far left, is where I saw these items.
okay.
Exhibit 5 shows the new wood that was put in, the door. 5 is just more items that were there on the property, and this shows the complete back of that far left building at that time. Exhibit 6 and 7 again, just showing the wood. Based upon the investigation, I issued a notice of violation to the respondent on February 20th, 2025, marked as County's Exhibit 8. In the notice, I cited the following Martin County Code violations: Section 105.1, permits required. Notice of violation.
Okay.
In the notice of violation, the respondent was given until March 6, 2025, to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on March 14, 2025, and is marked as County's Exhibit 9. The return mail was not received, therefore on March 31st, 2025, I posted the property and the Martin County Admin Building. The affidavit of posting is marked as County's Exhibit 10.
Got it. Okay.
I did receive an email from Independent Construction Company. However, no permits have been issued within that time that was allowed. I recently went back to the property, and it appears more work has been done. More work has been done at the units 5 and 6, which is the building to the far left. Exhibits 11 and 12 actually show what I saw then.
All right, and what work specifically?
The windows, the doors, and then the back lanai.
Are all new, okay.
Yeah.
All right.
I went back to the property again on April 15th and saw that the cited violation had not been corrected. Exhibit 13 shows what I saw then. I also checked to see if a permit, well, let me show you the Exhibit 13 first. Sorry. So everything still remains in place, and it appears that people are living in these 2 units.
Oh, okay. So the one building is actually a 2-unit,
Yes.
Like a little cabin, yes. Okay.
Yes. That's what it appears to
Okay.
me. Yes. So that was Exhibit 13. And then I also checked to see if there was permits for the work that had been issued, and it had not at that time. So that's my Exhibit 14, showing that no work was done. However,
And what
As a-
was the date of that check?
I don't,
Is it recent?
yes, I think it was last week.
Okay.
But then I checked it also yesterday,
All right.
and I do now see that there are current permits in review. However, nothing has been issued. And as you saw from the pictures, the work has already been done.
Okay, so applications made but not issued. yet.
Correct.
Okay, got it?
So I request that all the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent be ordered to comply with the cited provision of the Martin County Code by May 30th, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. All right, and who do we have on behalf of the trust? If you'll raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And your full name, sir?
Fred Russacker.
Okay. And what is your relationship to the
I am
trust?
son of my mother, who passed in 2015, who put the property into a trust.
Okay, and are you the successor trustee?
I am not. My
Okay.
sister is.
Your sister is,
I
okay,
can-
so,
I'm the one that can can speak about this, but I am not the successor.
all right, but you do have authority to
Yes.
appear on behalf of the trust?
Absolutely.
Okay. And, all right, so you've heard what the county has to say. What do you have to tell me?
We just need a little more time, Your Honor, to get this permit taken care of.
Okay,
That's it. I'm not gonna, a lot of these things that I'm seeing were the first that I've seen, because there was nothing on the sheet that stated just that we needed permits. So it was a very broad thing, and some of what she said is not quite true. Those windows were already in there, but there are a few that were replaced, and we're gonna handle it, and we're gonna be in compliance.
okay, and you're looking at what? Is that the
I'm-
notice of violation?
Yeah, I have the violation. It doesn't, I've dealt with code enforcement many times in the property, and they always give a list of what you did. And this was one that was just said that, it was almost like quoting the statute, that we needed permits and things like that. Nothing was identified. I don't know why this was actually initiated. We've been there since 1972. And, it was, we had some disgruntled tenants that were, that've been there since the COVID and hadn't paid us, so. But that doesn't really matter. We want to be in compliance, and I plan on doing it 100%.
I'm looking at what's marked as Exhibit 8,
Well,
and it's the notice of violation, and it looks specific enough.
I wasn't given that information on this piece of paper.
What is that? I don't know.
This was what they put on the complaint. It didn't have any,
NCA. That's when I posted the property.
but it didn't say,
Oh, that was the
window, it didn't
post.
say that. And then what happened is I spoke to her, and this person sitting next to me, I don't mean to know your name, Deborah. And then when I went in to see about getting the permits, I found out that you can't have a permit when it's a trust. So I applied at the building department for a review of our trust papers, and they said that you got to have a licensed contractor.
That's correct.
That was the first time that I'd heard that there was a problem with the lanai, or that there was doors, that I didn't, none of that was written down for me.
Understand that, and
Do you have any questions regarding this notice?
I'm just going to say that as dealing with a trust, I mean, there are certain things you're supposed to know how to do. One of them is that if you're not an individual you're not going to qualify under the statute
Well, I
as an
have-
owner-builder.
I did find that out. Yeah, and that's why we hired independent
All right.
to pull the permit.
So is 155 Southwest Canner Highway a good address?
That is the address.
Okay, well, that's where things were going, and,
No, I didn't, but there was nothing that, specified what building, where it was. There's 3 cottages there. There's a restaurant, a place where my mom lived. And but that's okay. I found out when I went and I spoke to the building department. They looked up the records and they said there was a problem with the back patio, which, was changed. And there's 2 windows that were put in.
well,
And we're going to get the permits for
and
it.
it sounds to me like you're not contesting that part of it, so.
I'm
I think-
good. I just need a little more time. What happened is, because I tried to find out if we could do it through the trust, that delayed it, but then we hired independent, and she is in the process of, like 2 days ago, as you saw,
Yes.
applying for this, so.
Okay, all
I
right.
just need more time.
Okay. All right, so without objection, then I'll accept into evidence the county's exhibits 1 through 15 in this case. Does the county have any objection to additional time in the case?
No.
All right, so what are you proposing?
We're going to get the permit and get the approvals, and if it's, to do it as what the county's asking of us. 100%.
Okay, so maybe by the end of June, this should be a done deal?
Oh, yeah, well, I was hoping it was going to be done today, so I didn't have to come in instead of going to work, but I
Nothing
didn't want to
happens
not
that
be here.
Nothing happens that fast. Okay,
I'm fine.
all right. In that case, I'm going to find that the violation as charged does exist on the property. I'm going to order you to comply on or before June 30th, failing which a fine in the amount of $100 a day will accrue. I am going to award costs in the amount of $575 to be paid to the county at the conclusion of the hearing upon entry of this order. So that you're going to have to do. That's unfortunately, for the pleasure of being here. Hearing, investigation, the whole thing, so.
Understood.
All right, June. Okay, we can give you a copy of this order. You can take it with you, okay? I'm going to ask staff to do that, if you will. Thank you. All right, and good luck. You can follow Miss Bradley out, and she'll give you a copy of the order.
Thank you.
All right, let's see. We back to the top of the batting order? All right, so this is case number ENF 2024-070370. Ola Terry Danette. That can't be right. It's probably Terry Danette Ola. Let me catch up here. Let's see, Mr. Counselor, do I have an order or no?
You should have a stipulation agreement, sir.
Stip. Okay, I'm looking. Three, 7. And you're right, I should have one. I don't see it.
Placed up there.
Maybe just clipped together or something. We'll find it. You go ahead and, I need to swear you in. Do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. And whenever you're ready.
My name is Chris Council. I've been sworn in. I am a code compliance investigator for Martin County. The owner has, the respondent is Terry Danette Ola, is not present, but she has entered into a stipulation agreement as of April 15, 2025.
Okay.
This case concerns the property at 5915 Southwest Ludlam Street in Palm City, Florida, which is located within Martin County. This case was not generated from an anonymous complaint. A copy of the property appraiser's record of ownership is County Exhibit 1, showing that the property owner is Terry Danette Ola. On November 12, 2024, I inspected the property. At the time, I observed expired permit application for sheds on the property. At the time I photographed the property, the photographs accurately show what I saw then, and it's marked as County Exhibits 3 and 4, with County Exhibit 2 being, Exhibit 2 is the front gate to the property.
Okay.
Exhibit 3 is the two structures in question. Exhibit 4 is a permit history for the property, showing that she had 3 expired permits for, or 3 non-issued permits for the sheds. Based upon the investigation, I issued a notice of violation to Terry Danette Ola on November 13, 2024, marked as County Exhibit 5. At the time, she was cited for expired applications to get the 3 permits basically issued for the pre-existing sheds. In the notice of violation, the respondent was given until November 27, 2024. To correct the violations, was informed they need to contact Martin County Code Enforcement. On January 21st, 2024, I again inspected the property. At the time, I observed the sheds on the property, and the application is still not issued. At the time I photographed the property, the photographs accurately show what I saw then, which are County Exhibits 6 and 7. 6, that's just showing the address. 7, the sheds are there. And Exhibit 8, showing that permits still hadn't been not issued. Based upon the investigation, I amended my notice of violation to building without a permit to Terry Danette Ola on January 23rd, 2025, marked as County Exhibit 9. So basically, seeing the work was done and the applications still hadn't turned into permits and been issued, I cited her for building without a permit. In the notice of violation, in the amended notice of violation, the respondent was given until January 6, 2024 to correct the violation, and informed them to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on March 17, 2025, marked as County Exhibit 10. The return receipt was not received, so on April 2nd, 2025, I posted the property, a photo of the posting, and the affidavit of posting are County Exhibits 11 and 12. She did submit additional paperwork, so I was hoping that the permit would be issued, but the permits still haven't been issued. So on April 15th, 2025, the owner entered into a stipulation agreement at the, basically requesting that the time be extended until July 31st, 2025, and she did pay the $350 of agreed fee to enter into the stipulation agreement. And that concludes my testimony.
All right. And I'm looking at the annotation of Exhibit 13, where it talks about no slab. What, do you know what that means?
Basically, the buildings in question are, they're sheds, but they exceed the building department's requirement to be designated as a shed because they're too big, so they're a miscellaneous structure. But basically, she's building buildings on the ground without putting a slab down first.
That's what I was thinking it meant, but I wasn't quite sure. Thank you. All right. So without objection, I'll accept into evidence the county's Exhibits 1 through 13 in this case. And looking at the stipulation, find that it is appropriate to enter the agreed order based upon stipulation requiring compliance by July 31st, 2025, and the payment of $350 in administrative costs. And note for the record that Terry Danette Ola has signed on behalf of herself, and Officer Counselor, you have signed on behalf of the county. Okay.
Yes, sir.
We'll enter the order. All right. Let's let's see, you've got a couple more here. Royal Palm Stewart, MHC LLC. This is case number ENF 2024-120195-01. And again, whenever you're ready.
My name is Chris Counselor. I've been sworn in. I am the Code Compliance Investigator for Martin County. The respondent, Royal Palm Stewart Mobile Home Park LLC, is not present. This case concerns the property. Okay.
Okay. Sorry, ladies, I didn't realize you were waiting. We'll get to you directly.
According to the official records of property appraiser, the Martin County, the property owner is Royal Palm Stewart Mobile Home Park LLC. A copy of the property appraiser record of ownership is County Exhibit 1. On December 10, 2024, I inspected the property. At the time, I observed a damaged fence and a work site was dug up and needed to be filled back in and the job site secured. At the time I photographed the property, the photographs accurately show what I saw then, and it's marked as County Exhibits 2 through 7. So Exhibit 2 is a down fence section for a fence that basically is the perimeter to the park. Exhibit 3, another fence section down. Exhibit 4, more fence sections either in disrepair or damaged or completely down. Exhibit 5, more damaged fence sections. Exhibit 6, this is the job site. From what the neighbor said, I guess a pipe was repaired. They dug the hole, they fixed the pipe, but they never filled the hole back in. And they just had this makeshift fence around it. Exhibit 7 is a more damaged fence. Based upon the investigation, I issued a notice of violation to Royal Palm Stewart Mobile Home Park LLC on January 2nd, 2025, marked as County Exhibit 8. In the cited notice of violation, they were cited for Section 21.99 accessory structures to repair the fence and Section 21.95 to secure the job site. In the notice of violation, the respondent was given until January 31st, 2025 to correct the violation and was informed of the need to contact Martin County Code Enforcement. Compliance was not achieved, and a notice of hearing was issued by certified mail on March 17, 2025, and is marked as County Exhibit 9. The return receipt was received on March 24, 2025, and is marked as County Exhibits 10 and 11. 10, return receipt was signed for. And Exhibit 11, return receipt was signed for. No call or letter from the property owner was received in time allowed. Therefore, I went to the property again yesterday, April 15, 2025, and saw the decided violations had not been, some had been corrected, but some had not. So basically, the violation of 21.95 for the job site, the hole had been filled in and the fence had been removed, but the section 21.99, the fence was still damaged. At the time I photographed the property, the photographs accurately show what I saw then, and there'll be exhibits 12, 13, 14, and 15. Exhibit 12, fence still hasn't been repaired. 13, fence still on the ground. 14, 15, yeah, I'm sorry, 14,
Yes.
damaged fence, and Exhibit 15, fence completely down. Based upon the testimony and the evidence, I request that respondent Royal Palm Stewart Mobile Home Park LLC be ordered to comply with the cited provisions of Martin County Code by May 30th, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 per day until the violation is corrected. The county has incurred the cost of $575 conducting this investigation and requests that the county be reimbursed these costs at the conclusion of today's hearing.
All right. Okay, and ladies, are you here on behalf of Royal Palm Stewart? Yes. Okay. Come on up to the podium, and if you'll raise your right hands. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and your names and your affiliation with Royal Palm Stewart Mobile Home.
I am Tammy Lemke, Lembke, and I am the community manager.
Okay, Lemke. All right,
My
and
name is Mamie Jones, and I am employed with Lakeshore Management. I'm from the management company.
okay. All right. Okay, you've heard what the county has to say. Anything you want to tell me?
Yes, as far as the fence goes, he is correct. The fence was still down as of yesterday. We did enter into a contract to have the fence replaced. I do have a copy of the contract with me today. It is starting as of today the work to be started, and it will be completed by by May 16th. And I do have a copy of the
All
contract.
right, perhaps you want to show that to the county? All right, and who is the contract with?
The contract is with Union Fence.
All right. Okay. And
I hope they didn't start the work today.
I see the note on the contract, it says to be permitted, and the answer there is yes.
Yes.
So they know they have to get a
Yes,
permit.
they are aware that they have to receive a permit. Yes.
All right. Okay. So the county is asking for you all to comply by the end of May.
Yes. Yes.
See any problems with that?
No, sir.
All right.
Not at all.
All right. Okay. All right. And no objection to any of the evidence that's been submitted?
No objection. The whole has been completed. It was completed as
Okay.
of last Friday, so that.
Okay, and we did hear testimony from the county on that, so, all right, so without objection, I'll accept into evidence the county's exhibits 1 through 15. Based upon that evidence and what I'm going to call, can we take a screenshot of that? Not that.
Actually, I have a copy. This copy is mine. I can leave that copy
I
with
have a
the.
copy of it, too.
I was going to mark it as Respondents Exhibit 1,
Okay.
and unless there's an objection, I'll accept that into evidence.
doubt highly there will be.
All right. Okay, so based upon that evidence as well, I'm going to find that the violation as charged does exist on the property, order compliance on or before May 30th, 2025, failing which a fine in the amount of $100 per day would accrue. I am going to award costs in the amount of $575 to be paid to the county upon entry of this order. I suppose if you had,
No objection, Your Honor.
all right. All right, so without an objection, I'm going to accept this into evidence as Respondents Exhibit 1. And let me just make sure. Okay, and it is executed on behalf of Royal Palm Stewart MHC LLC
Yes.
by Brian Kissinger.
Yes.
Okay. All right. Okay. Ms. Bradley, can you make a copy of this? We can give this back to them. Just mark it as Respondents 1 for the case. All right. And then basically make sure that you get not just the building inspection, but notify code enforcement officer counselor so
Your Honor,
that
if
he'll
I-
be aware of it.
Excuse me for breaking in, but
Yes.
we just checked. The contractor is not licensed in Martin County, which means they won't be able to pull a permit until they get a license.
Right.
So want to go out another month to make sure these people don't run afoul of.
That's fine. They can reciprocate a license, but
It is an extra little hitch that
Okay, so what is the county suggesting?
June 30th.
Basically, the contractor that's hired to do the fence, they're not licensed in Martin County, so they can't do the work until they get their license registered with Martin County.
When they go to pull the permit, they're going to tell them no.
So let's say June 31st,
Okay.
because I don't want you to fail.
Okay.
Thank you.
Thank you, sir.
Okay. All right, I'm going to go ahead and enter the order. And as I say, make sure that Officer Counselor is aware of the completion, because sometimes between building and code enforcement, that's right hand, left hand, so, okay. All right. And then you do have to pay the $575, but that'll be paid in due course, I'm sure. Okay, so I think that concludes it. You will get a copy of this.
Okay.
If,
Is there a way I can get a copy of it now?
yes, that's more just, I'm looking at Miss Bradley.
I have a hard time getting this together.
Go ahead, thanks. All right, very good.
Thank you, sir.
Yes, ma'am, thank you. And we'll
Where am I watching?
move on. The next case is Co. S. Knox LLC. That's also your case, Officer Counselor. It's case ENF 2024-120361. Co. S. Knox LLC is the case name. And whenever you are ready.
My name is Chris Counselor. I've been sworn in and code compliance investigator for Martin County. The respondent's KOH-S Knox LLC is not present. This case concerns the property at 7770 Southwest Rattlesnake Run, Palm City, Florida, located within Martin County. This case was not generated from an honest complaint. According to the official records of the property appraiser of Martin County, the property owner is KOH-S Knox LLC. A copy of the property appraiser's record of ownership is County Exhibit 1. On December 26, 2024, I inspected the property. At the time, I observed an expired permit application for fence sections. At the time I photographed the property, the photographs accurately show what I saw then. It's marked as County Exhibits 3 and 4, with Exhibit 2 being the expired permit letter, and a screenshot of the permit status being County Exhibit 5. So County Exhibit 2 is the expired permit application letter. It wasn't an issued permit. It was just an application.
Okay.
Exhibit 3 is my inspection, but work has been done because these fence sections were there. So that's Exhibit 3. Exhibit 4, you can see in relation to the house on the property, I got 2 sections of fence. And then Exhibit 5 is showing that basically the fence application was never turned into a permit. Based upon the investigation, I issued a notice of violation to KOH-S Knox LLC on February 17, 2025, and it's marked as County Exhibit 6. In the notice of violation, he was cited for Section 105.1 to complete his permit application. In the notice of violation, the respondent was given until March 3, 2025 to correct the violation. I was informed of the need to contact Martin County Code Enforcement upon doing so. Wait, yes. Compliance was not achieved, and a notice of hearing was issued by certified mail on March 26, 2025, as marked as County Exhibit 7. The return receipt was not received, so on April 2nd, 2025, I posted the property. A photo of the posting and the affidavit of posting are marked as County Exhibits 8 and 9. Since the fence has already been built, I amended my violation to building without a permit under the same section of code, Section 105.1, as adopted by Section 21.1, General Ordinances, Martin County. So on April 3rd, 2025, I amended my notice of violation and my notice of hearing and issued it then by certified mail and are marked as County Exhibits 10 and 11. So I'm sorry, that was my posting, and that was my affidavit posting for the, but upon my posting, I still had the correction of basically complete the permit application. But since the work was done, I amended it. Basically, all I amended was the correction, was to go ahead and obtain a permit for the fence section since they'd already been built. So the amended NOV was for April 3rd. I also amended the notice of hearing on April 3rd. And then on April 3rd, I also posted the property again. So Exhibit 12 is my second posting, and Exhibit 13 is my affidavit of posting. No call or letter from the property owner has been received within the time allowed. Therefore, I went to the property again on April 15, 2025, and saw that the cited violations had not been corrected. At the time I photographed the property, the photographs accurately show what I saw then, which will be County Exhibits 14, the fence sections, 15, 16, and 17. And Exhibit 18 is basically the current permit status showing that
Got
it's
it.
still an expired application. I request that all county's exhibits be received into evidence. Based upon the testimony and the evidence, I request that the respondents, KOH S. Knox LLC, be ordered to comply with the cited provisions of the Martin County Code by May 30th, 2025. If not in compliance by then, be required to pay a fine in the amount of $100 per day until the violation is corrected. The county has incurred the costs in the amount of $575 conducting the investigation and request that the county be reimbursed this amount at the conclusion of today's hearing. And that concludes my testimony.
Okay. Anybody here on behalf of Co. S. Knox LLC? Looking out, seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 18 in this case. I think this is the first time I have ever had a case that it was on Rattlesnake Run. I didn't know we had one of those.
That west.
Yeah. Okay. All right. Based upon your testimony and the evidence, I'm going to find that violation as charged does exist on the property in order compliance on or before May 30th, 2025, failing which a fine in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of today's hearing. And it is so ordered.
Thank you.
Thank you. Okay, let's see. Ms. Espy, on your back. This is the James B. Ray Senior Revocable Living Trust case. It's case ENF 2024-090102. And which way did she go?
Kelly's is off. Kelly's.
I didn't scare you away, did I?
I did. 102.
One 102. I'm looking, I'm not seeing it on the screen.
1 second, Your Honor. We'll pull it up a different way. Is it in there?
That's fine, and I'll just follow along with you.
So he sees it.
Okay. Okay.
There we go. You've already been sworn in, right?
Yes.
Okay.
My name is Maria Espea, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, James B. Ray Senior Revocable Living Trust, is not present. This case concerns a property at 4729 Southeast Compass Way in Stuart, Florida, in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is James B. Ray Senior Revocable Living Trust. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay, and just note for the record, I'm looking out, there's no one here on behalf of James B. Ray Senior Revocable Living Trust. Seeing no one, go ahead. Oh, this is a step.
Correct. And this is the property appraiser Exhibit 1.
Okay.
On August 15, 2024, Officer Counselor inspected the property. At that time, he observed a damaged roof and exterior issues with the property. At that time, he photographed the property. The photograph accurately shows what he saw then, marked as County's Exhibits 2, 3, 4, and 5. Number 2 is roof damage. You could see it right here where my pointer is. And there's some around, but the most visible one is that one.
Okay.
3 is a carport roof area. The roof is missing pieces. Number 4 is just another photo of the exterior of the home. Number 5, again, it's more exterior photos. This case was transferred to me on November 8th, 2024. I re-inspected the property and seen that the violations remained. The inspection photos are marked as County's Exhibits 6, 7, and 8. Number 6 is a different view, and here it shows where they covered, and I guess some blocks are here to make sure the water doesn't go through.
Is this building occupied?
I was informed it is occupied.
Okay.
This is exhibit number 7, just a different view of the same roof that was missing.
That we saw before.
And number 8, it's just another angle of that covered piece on top, right here.
Okay.
Based upon the investigation, I issued a notice of violation to the owner on November 14, 2024, marked as County's Exhibit Number 9. In the notice, I cited the following Martin County Code violation: Section 21.115, Roofs and Drainage, General Ordinances, Martin County Code, and Section 21.111, Protective Treatment, General Ordinances, Martin County Code. In the notice of violation, the respondent was given until December 16, 2024, to correct the violation, and was informed of the need to contact Martin County Code Enforcement upon doing so. On January 14, 2025, I spoke to John, a man named John, who claimed to be the owner and requested an extension. After the 30-day extension, compliance was not achieved, therefore a notice of hearing was issued by certified mail and regular mail on March 14, 2025, and is marked as County's Exhibit Number 10. The return receipt was not returned, so on April 1st, 2025, I posted the property in the Martin County Admin Building. The affidavit of posting is marked as County's Exhibit Number 11. Shortly after the property was posted, I received a call from Jim Ray, one of the trustees for the property, and a stipulation agreement was executed by the county and signed by him. He has paid an administrative cost of $375 and agreed to comply by September 16, 2025.
350 or 375? The order says 350.
350, I'm sorry.
Okay.
Correct.
Just checking. All right, and he's going to comply by September 16th, 2025. Okay. All right. All right, note for the record that the stipulation is signed by James B. Ray Jr. as trustee and by Ms. Espiat on behalf of the county. I'll find that it is appropriate to enter into an agreed final order approving the stipulation as submitted, and note that the $350 in administrative costs have been paid to the county.
Thank you.
Thank you.
Before you go, Ruth, Your Honor, I just have an application before Officer Espiat leaves. It's to an admission from today's docket concerning case ENF 2024-060615, an order of continuance signed by the magistrate last month for Evelyn R. Comstock.
Yes.
I have a copy of the order here. The property has come into full compliance, so at this time, we would move for the case to be dismissed.
All right, and I actually was going to bring that up at the end. I kept that in my file as well, granting the continuance. Okay, based upon the county's representations that the case is in compliance, we'll dismiss the case.
Thank you, Your Honor.
Thank you.
Thank you.
I guess our other one is off. Yeah.
Okay. Let's see, Ms. Bradley,
Yes, sir.
we're up to you. Okay. This is a Palmer case. It's case number 15-0097780, Sherry and Gordon Palmer, and it's a fine reduction stipulation and agreed recommended order. If you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, what have we got?
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 4645 Southeast Pompano Street in Stewart in Martin County, Florida. On February 17th, 2016, an order finding violation was issued by the code enforcement magistrate to Sherry Palmer and Gordon Palmer for Section 105.1 FBC permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code. So Exhibit 1 is the property appraiser,
Okay,
showing the Palmers are the owners. Exhibit 2 is the original order that was put in place.
all right.
Compliance was required by April 19th, 2016. On December 2nd, 2024, an affidavit of compliance and accrued costs and fines was issued reflecting an outstanding fine in the amount of $312,200 plus cost in the amount of $575. K2 Real Estate Investment LLC is in contract to purchase the property on May 29th, 2025 through a bank-approved short sale. Staff has determined that a lien reduction is warranted. The contract purchaser was not responsible for the violation. However, they offered to pay $31,277.50 to resolve the outstanding fines which have accrued. Exhibit 3 is the affidavit of compliance with fines. And then Exhibit 4 is the reduction request from K2 Real Estate Investment. And that concludes my testimony for this one.
Do they, looking at this, they don't actually,
They don't take possession until May 29th.
okay, all right. And they've offered to pay $31,277.50.
Yes, sir.
10% of the value. Okay. All right. Note that it is signed by Kenneth Morris, a principal at K2 Real Estate Investment LLC, and he also signed the request for reduction. All right, Ms. Bradley, you're going to sign this as well?
Well, I guess so. I thought I did.
All right, if you do, then I may sign it. All right, and so I'm going to find that it is appropriate to recommend to the county commission that they approve the fine reduction as stated in the stipulation.
Thank you.
All right, let's see. So we've got exhibits 1 through 4 in this case, and I'm going to accept those into evidence as well. And let's see, it was 312,575 down to 31,277. Okay. All right, next case is case 16-010-3045. Terry Lou Jacobson and Crystal Fenton are the owners. This also is a fine reduction stipulation and agreed recommended order.
Yes, sir.
What have we got?
My name is Rachel Spradley, and I have been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 1781 Southwest College Street, Stewart, in Martin County, Florida. And Exhibit 1 is the property appraiser showing the ownership. On October 19th, 2026, an order finding violation was issued by the code enforcement magistrate to Terry Jacobson and Crystal Fenton for Section 21.99 accessory structures, General Ordinances, Martin County Code, Section 67.201.A, nuisance declared weeds, undergrowth, General Ordinances, Martin County Code. And Exhibit 2 is the original order put in place.
All right.
Compliance was required by August 22nd, 2016. On June 19th, 2023, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $308,000 plus cost in the amount of $575. Staff has determined that a lien reduction is warranted. The respondent was responsible for the violation, and they brought the property in compliance and have offered to pay $17,246 to resolve the outstanding fines which have accrued. In addition, staff has considered the $172,460 assessed value of the property. So they're paying 10% of the property value on this one. Exhibit 3 is the affidavit of compliance with accrued fines that was recorded. And Exhibit 4 is Mr. Jacobson's request for reduction.
Okay. All right, based upon your testimony and the stipulation in front of me, I'm going to find that it is appropriate to enter into an agreed recommended order in this case. Note for the record that Terry Jacobson has signed on behalf of the owners, and that Ms. Bradley, you've signed on behalf of the county. Okay. Let's see. Next one is Dawn Marie Decker. It's case ENF 2019-050-887. And that's also a fine reduction.
Yes, sir.
And what have we got?
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 3277 Southeast Birch Avenue, Stewart, in Martin County, Florida. On September 18th, 2019, an order finding violation was issued by the code enforcement magistrate to Dawn Marie Decker for Section 67.201.B, nuisance declared trash, etc., General Ordinances, Martin County Code. So Exhibit 1 is the property appraiser showing that Mrs. Decker is the property owner.
Okay.
Exhibit 2 is the original order that was put in place on the property.
All right.
Compliance was required by October 31st, 2019. On December 13th, 2019, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $2,000 plus cost in the amount of $575. Pursuant to Section 1.98B General Ordinances, Martin County Code, no code enforcement lien shall be reduced to a value less than 10% of the total fine amount or 10% of the value of the property, whichever is less. The portion of the lien attributed to the cost shall not be subject to reduction. Staff has determined that a lien reduction is warranted. The respondent was responsible for the violation. They brought the property into compliance and have offered to pay $200 plus the cost in the amount of $575 for a total amount of $775 to resolve the outstanding fines which have accrued. So that concludes my testimony for this one. Exhibit 3 is the original affidavit of compliance with fines.
Okay.
And then Exhibit 4 is Mrs. Decker's request for reduction.
All right. Okay, and of course, the stipulation does recite all of that, and it's also been executed by Dawn Marie Decker on behalf of herself and by Ms. Bradley on behalf of the county. I'm going to find that it is appropriate to recommend to the county commission that they approve this stipulation.
Thank you.
Okay, a couple left. Next one is Lisa Chitty and Chris Bishop. It's ANF 2023-020-728-01, and that's also a fine reduction.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator from Martin County. This case concerns the property located at 8004 Southeast Carlton Street, Hope Sound in Martin County, Florida. On April 16, 2025, an order finding violation was issued by the code enforcement magistrate to Lisa M. Chitty and Chris Bishop for Section 67201A, weeds, nuisance declared undergrowth, General Ordinances, Martin County Code. So Exhibit 1 is the property appraiser showing the ownership.
Okay.
Exhibit 2 is the original order that was put in place. And Exhibit 3 I have to pull for you from the folder because it was not recorded at the time. And actually, it doesn't look like we've still gotten it back for the affidavit.
Okay, just walk me through it.
Okay, so compliance was required by July 31st, 2023, and an affidavit of compliance was recorded. Hold on, and I'll tell you. I'll at least tell you how many days it was, because I don't have the affidavit. So it took them 401 days to bring it into compliance.
And is that total fee that shows of $40,675, is that
Yes, sir.
valid?
Oh, here's the affidavit.
Okay.
So the affidavit was recorded on 4/4 of 2025.
All right, we're going to enter that as exhibit.
Yes, I'll put it in Exhibit 3 for you.
Okay. All right.
Okay. Staff has determined that a lien reduction is warranted. The respondents were responsible for the violation and have brought the property into compliance. They have offered to pay $4,067.50 to resolve the outstanding fines which have accrued on the property. And Exhibit 4 is their request for the reduction.
Okay. All right, and note for the record that the stipulation in front of me does recite those facts. The fine was $40,100 plus cost in the amount of $575. They've offered to pay $4,067.50, 10% of the total accrued amount. And that the respondents, Lisa Chitty and Chris Bishop, have both signed on behalf of themselves. And Ms. Bradley, you've signed on behalf of the county. So I'm going to go ahead and find it's appropriate to recommend the agreed order, or recommend the county commission approve the stipulation.
Thank you.
Okay. All right, let's see. Next case is case ENF 2024-070619-01. It's Holly A. Speakman as the respondent, and this also is a fine reduction stipulation.
Yes, sir. My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 4440 Southeast Chesapeake Bay Drive, Stewart, in Martin County, Florida. On October 16, 2024, an order finding violation was issued by the code enforcement magistrate to Holly Speakman for Section 67201B trash, nuisance declared trash, etc., General Ordinances, Martin County Code, Section 91.34A, generally inoperable vehicles, General Ordinances, Martin County Code, and Section 67201A, weeds and undergrowth, nuisance declared, General Ordinances, Martin County Code. Compliance was required by November 29, 2024. On January 30th, 2025, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $12,400 plus cost in the amount of $575. So Exhibit 1 is the property appraiser with the current owner's information on it.
Okay.
Exhibit 2 is the original recorded order that was put into place.
Mm-hmm.
And then Exhibit 3 is the affidavit of compliance with fines, showing the amount due. ABJJ Property Rentals LLC are the current owners of the property pursuant to a warranty deed recorded in Official Record Book 3482, page 1278, Martin County, Florida Public Records. The respondent has no remaining interest in the property. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation. However, they brought the property into compliance and have offered to pay a fine in the amount of $1,297.50 to resolve the outstanding fines which have accrued. And Exhibit 4 is their request for reduction.
Okay. All right. All right, the stipulation, of course, recites all of that, and based upon that, and Exhibits 1 through 4 in this case, which I'll accept into evidence, I find that it is appropriate to ask the county commission to reduce the fine from $12,400 to, I guess it's, well, it's plus costs of $575 down to $1,297.50. Note for the record that Bruce Oreski has signed on behalf of ABJJ Property Rentals LLC, and Ms. Bradley, you have signed on behalf of the county, and I'll approve it as submitted. Okay. All right. As I indicated prior to the hearing, I did not review the minutes for March, so I will do that and bring them to the next hearing. And do we have anything else to come before us today?
No, sir.
No, Your Honor.
Okay, all right, good. So we will see you when?
May 21st.
May 21st. Okay, very good. Thank you all. We stand adjourned.
Thank you.